In this video, I will show you how to write a business and purchase sales agreement and discuss the key concepts and key provisions of these agreements. I'm Santiago Cueto, board certified international business law expert and best-selling author. In my 30 years of practice, I've helped thousands of companies build and structure airtight purchase and sales agreements. Most people think buying a business is just like buying a car. You shake hands, you sign a document, you walk away with the keys, but here's what nobody tells you. A poorly drafted purchase agreement can cost you millions of dollars. It can expose you to hidden liabilities. It can destroy the deal before you even close. Today, I'm going to walk you through exactly how to protect yourself. Let's start with the most fundamental question. What are you actually buying? This isn't obvious. You might think you're buying a business, but legally, you're buying one of two things. You're either buying assets or you're buying stock. This distinction changes everything. In an asset purchase, you cherry pick what you want. You buy the equipment. You buy the customer list. You buy the intellectual property. You leave behind the liabilities. The debts stay with the seller. The lawsuits also stay with the seller. This is usually the safer route for the buyer. But in a stock purchase, you buy the entire company. You get everything, the good and the bad. All assets come with you. All liabilities come with you, even the ones you don't know about yet. Even the ones the seller didn't disclose. This is riskier, but it's sometimes necessary. Some contracts can't be transferred. Some licenses can't be reassigned. So you have to buy the whole entity. Now, your purchase agreement must clearly state which structure you're using. This goes in the very first substantive section. Don't bury it. Don't make it ambiguous. State it clearly up front. Asset sale or stock purchase. Now let's talk about purchase price. This seems simple. It's not. The purchase price has multiple components. You have the base price, you have earnouts, you have adjustments, you have holdbacks. Each one needs its own provision. The base price is your starting point, but it rarely stays static. Most agreements include a working capital adjustment, and here's why. The business operates between signing and closing. Inventory levels change. Accounts receivables change. Accounts payable change. You need a mechanism to adjust for this. Otherwise, the seller could drain the accounts right before closing. Your agreement should specify a target working capital. You measure actual working capital at closing. You adjust the price up or down based on the difference. This protects both parties. Make sure you define exactly what counts as working capital. Be specific. Ambiguity here leads to post-closing disputes. Earnouts are another critical component. These are conditional payments. The seller gets them only if the business hits certain targets after closing. Maybe it's revenue targets. Maybe it's profit targets. Maybe it's customer retention targets. Earnouts align incentives. They bridge valuation gaps, but they're also a source of endless litigation. If you include an earnout, define the metrics precisely. Specify the measurement period. Specify who measures. Specify what happens if the buyer changes the business model. Specify what happens if there's a dispute. Leave nothing to interpretation. If you're finding this video valuable, do me a favor. Hit that like button right now and subscribe to this channel. I share practical legal strategies like this every single week. These insights can save you from costly mistakes. Now let's keep going. Representations and warranties are the heart of your agreement. These are promises the seller makes about the business. They promise the financial statements are accurate. They promise there's no undisclosed litigation. They promise they own what they're selling, and they promise the contracts are valid and enforceable. Every representation matters. They establish your baseline. If something turns out to be false, you have recourse. You can sue for breach. You can reduce the purchase price, and you can sometimes unwind the deal entirely. Your job as a drafter is to make these representations comprehensive, cover financial matters, legal compliance, and employee issues. You should also cover intellectual property and environmental matters. In short, cover everything that could affect the value of what you're buying. But here's the key. Don't just copy and paste from a form. Customize these to your specific deal. If you're buying a software company, dig deep on IP ownership. If you're buying a manufacturing business, focus on environmental compliance. If you're buying a service business, focus on customer contracts and key employees. Indemnification now is where you allocate risk. Something goes wrong after closing? Who pays? The indemnification provision answers this question. It creates a contractual remedy beyond basic breach of contract. Now, you need to specify what triggers indemnification. Usually, it's a breach of representation or warranty. It can also be specific liabilities. Maybe there's pending litigation. Maybe there's a tax dispute. The seller agrees to indemnify you for these specific items. Set clear limits, include a deductible or a basket. The buyer absorbs small losses. Only claims above a certain threshold trigger indemnification. This prevents nickel and dime disputes down the road. Set a cap on total indemnification. The seller's liability isn't unlimited. Usually the cap is a percentage of the purchase price. And specify the survival period. Representations don't last forever. Most survive for 1 to 2 years after closing. Some survive longer. Tax representations might survive for the full statute of limitations. However, fundamental representations about ownership and authority often survive indefinitely. Create an escrow or holdback mechanism. Don't pay the full price at closing. Hold back a portion. This gives you a fund to satisfy indemnification claims. Otherwise, you're chasing the seller for payment later on. That's really difficult and it's expensive. The escrow solves the problem. Now, here's what you need to remember. A purchase agreement is your protection. It's not just paperwork, it's your financial safety net. Every provision I discussed today serves a purpose. It allocates risks, it provides remedies, and it prevents disputes. Don't cut corners on this document. Don't use a generic template without modification. Every business sale is unique. Your agreement should reflect that. Get experienced counsel to draft it. Get experienced counsel to review it. The cost is nothing compared to what a bad agreement will cost you later. Now, if this video helped you understand purchase agreements better, hit that like button. Subscribe to my channel for more content like this. I break down complex legal topics so you can protect your business interests. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos here.